Thank you, Daphne and Pete, for coming, and also Matt. So Daphne is a partner in Perkins Coie's Technology Transaction and Privacy Group in Silicon Valley, and she plays an integral role within the firm's emerging companies and venture capital practice. She counsels companies on complex technology transactions with a particular focus on digital media, entertainment, open source, privacy, advertising, and the transfer of technologies from universities. Also, Daphne provides strategic intellectual property advice with respect to M&A and venture capital transactions. And we also have Pete. He is an associate in Perkins Coie's Technology Transaction and Privacy Group in Silicon Valley, where he structures documents and negotiates strategic transactions involving technology and advises clients on intellectual property issues in large corporate transactions such as mergers and acquisitions. Pete's clients span a broad range of industries, including AI, robotics, autonomous vehicles, SaaS, fintech, healthcare, and advanced materials. So I'll let you guys get started.
Thank you. Daphne, do you want to, I guess we were introduced, so I don't know if we need to do any more introductions, but I'm Pete. I'm an associate in our TechTrans office in Silicon Valley, and I'm going to be generally leading our presentation today, which is called Show Me the Money, Monetizing IP via Licensing. I think generally for the presentation, I'll give you the agenda here. I'll try at least. Okay. Our plan is just to go over IP 101 kind of in broad strokes. We won't get too in the weeds on things, but we want to give you just sort of a general idea of what type of IP we're dealing with. And then we'll dive into licensing and how you're going to monetize that IP, what a typical licensing agreement should have, what it looks like, and we'll finish with some sort of things to look out for, which we're calling traps for the unwary. But yeah, that's the plan for this morning's session. Daphne, anything to add before we jump in?
Well, when we talk about the licensing, we're also capturing, cloud offerings and other things like that, even the performance of professional services. So it's a very broad understanding of licensing. And also, I guess we'll get started. We will show you the money.
Sweet. Okay, so let's start just sort of going through IP in broad strokes. I won't read every slide because that's, everyone can read and that's going to be a waste of time. I think I'll just sort of add some context to the slides just generally. So when you're thinking about IP, you want to think about sort of two buckets. There's technology and then there's IP rights. Technology is what you would think of as, something like an embodiment. So like software code, right? That's technology. That has IP rights in it, right? So in a string of software code, for example, there are copyrights that are in it. So, by typing out some software code, you have created something, you've created technology, but there's a copyright in that technology. There's an IP right in that technology. So you always want to think about, I have technology, or I have something that I've developed. Now, what are my IP rights in that? That could be copyright. I could have patent rights. I could have trade secret rights. So just generally, when you're thinking about IP, this is a sort of framework from which to approach it.
And also when you're thinking about, when you're going into, let's say, getting funding for your company, you do want to think about all of those rights, because those are different ways that you can protect your IP, or that in fact is automatically protected. For copyrights, which you'll learn about shortly, that just happens. You don't need to go and file an application. It's just as soon as that code is embodied in a tangible form.
Right. Yep. So, when you're creating technology, or you've developed, a method for doing something that's unique, you want to think about what IP rights apply. And we'll talk about specific IP rights in a moment. So we'll start with copyright. As Daphne mentioned, one sort of misconception about copyright that even I had when I went into practice way back when was that in order to get copyright, you have to do some sort of filing or go to the government to obtain some sort of right. That's actually not true. Copyright is automatic upon it's called fixing something in a tangible medium of expression. Which is sort of legal speak for, typing something or writing something down or, recording something. Those are all in tangible media of expression. So if we're using software code as the example, you type out a string of software code that's fixed on a tangible medium of expression, i.e. your computer. Similarly, if you write a book, you write something that's, fixed in a tangible medium of expression. So that's automatically protected by copyright. Sorry, I lost my train of thought there for a sec. So with copyright, copyright protects these things that are fixed in a tangible medium. It does not protect ideas. So if I'm sitting around and I have a great idea about, how to do something, that's going to be protected by patent, which we'll talk about briefly in a minute. But that's not protected by copyright. You actually have to fix something in again, a tangible medium of expression. So I talked about how copyright is automatic. And by the way, software is typically protected by copyright, but there are often patent rights in software as well. But for an early stage startup, kind of if the first thing you're doing is coding things, that's going to be first protected by copyright. I talked about, not registering, it's typical not to register a copyright for mostly because if you register it, you have to publicly disclose it, right? But registration does have some benefits in certain instances. You can, for example, obtain special damages, and in order to bring a lawsuit for copyright infringement, you have to have a registered copyright. But typically, our clients don't register their copyrights. And unlike patent, it's not a substantive government review of the registration. So there's that as well. So a copyright holder has certain rights that are granted to them by statute, and these again are automatically granted, by virtue of the copyright being attaching to the work, right? So those rights are to reproduce, or otherwise known as copy, publicly perform, publicly display, distribute, and prepare derivative works. So, taking the example of a book, right? Like let's say Harry Potter. Harry Potter, when J.K. Rowling, setting aside publisher issues, when J.K. Rowling sits down and writes a 500-page book, she has the exclusive right to copy that book, to publicly perform it, publicly display it, distribute it, and prepare derivative works of it. The public performance right is more applicable to music. It's similar in music, right? If I record a song, I create a song and I record it, I'm the only one who has the right to go publicly perform that song. And using the derivative, talking a little bit more about derivative works, again, going back to the Harry Potter example, when those movies were created, those are derivative works of the book. So a derivative work is essentially something that, I hate to use the definition, I hate to explain it using the definition, but it derives from the work. So in order to create those movies, let's say I want to create a Harry Potter movie, I have to go get the rights from J.K. Rowling to prepare derivative works of the book. You will occasionally see other rights that are granted in a copyright license, like use, design, sell. Those aren't really applicable or appropriate. You always want to, when you're entering into a license agreement, you always want to use the rights that are granted in the statute. Now, talking a little bit about licensing, if I have the exclusive right to copy something and no one else can do it, if I want to, let's use the derivative work example again. I've written a book and I want to go, I think it's a good idea for someone to create a movie based on it because I'm going to get a lot of money from that. Well, how do I do that? I'm the only one who has the right to prepare derivative works of that book. Well, that's where licensing comes in. You can think of licensing as essentially a permission for someone else to exercise the exclusive rights you have under law. So if I have the exclusive right to prepare a derivative work of my book, in order to, if I want to give someone else that right, I have to license that right to them and allow them to do it. And under licensing, and we're going to get more into licensing, but basically, you obviously, when you grant someone a right to do things that only you have the right to do under law, you want to set parameters around that right? I mean, I want to say, okay, you can create a derivative work, but you can only create 20 of them. And that's, in order to set those terms, that's where a licensing agreement comes in. And so we'll talk about that. But I just wanted to sort of contextualize why we're talking about these background rights. Anything to add on copyright? Okay. Patent. Patent is a little bit more involved from a governmental perspective. Each country has their own patent laws. I'm only going to talk briefly about US law, but you generally file a patent on a country by country basis. There are there's a patent regime that will file a patent that applies to sort of not on a global basis, but on a more than one countrywide basis. But generally, if you're a company in the US, you want to file a patent in the US. You'll also want to consider filing, or if you have patentable subject matter, you'll also want to consider filing for patents in areas in which you might be doing business. So if you're going to be doing a lot of business in China, if you're going to be doing a lot of business in France or in the EU, you'll want to be looking at filing patents in those jurisdictions as well. The difference between patent and copyright, which I alluded to a little bit earlier, is that a patent protects an idea. It protects an invention. It doesn't protect the actual, tangible medium of expression. It doesn't protect the thing that's fixated on something, the book. It protects an idea. So, if you have a method for doing something, right? I can create something in this certain way. That is going to be patentable, not copyrightable. And a single product, so like my iPhone, has a slew of patentable inventions in it, or that it embodies. That's the term that we use. So patents, unlike copyrights, you have to file for a patent and you have to be granted a patent. Patent, the process of obtaining a patent is very involved. You work with a lawyer. There's a substantive full examination by a governmental agency. And that agency can review the correctness of its award. And one sort of odd thing about patent is that it's really a right to exclude others from doing something, but it's not necessarily a right to do something yourself. So if I file a patent and if I'm granted a patent for something, I have the right to tell someone else that, hey, you can't practice that method that I have a patent for. But that doesn't necessarily mean that you can practice that method, because there could be other patents that, by practicing that method, you may be infringing. But it's just sort of an odd quirk of patent law. But the substantive rights in patent are a little bit different from copyright. Your exclusive rights as a patentee are to make, use, sell, offer to sell, or import the invention. And as I said, you don't have the affirmative right to practice the invention. So if I have a patent on some sort of method for creating a product, but I want to monetize that, that's again where licensing comes in, right? I can grant someone else the right under my patent to manufacture, to use my, say it's a method of manufacturing, to use my method of manufacturing to create a product that they can go and sell. And then typically we would share in that, downstream revenue. But otherwise, if you just have a patent and you're sitting on it, you're not really making any money from it. You're just excluding other people from using it. Now you can bring lawsuits and things like that. And that's generally referred to as a patent troll. Doesn't actually use the patents. They just sort of sit around and wait for other people to infringe. But assuming that that's not really your aim, you're going to want to license that right. Yeah, so that's patent. A little different from copyright. Trademark. So trademark is, our clients do typically have trademark rights. It's not as typical to have in-depth trademark components in a license. But for example, if you are a company that has, well, let's start with what trademark is, then we can get to the licensing piece. A trademark is generally just a word or a phrase or a symbol that identifies you and distinguishes you in the marketplace. So if you think of the example I typically use is like the Nike swoosh or the Target. When you see that as a consumer, you automatically make that association. You see the swoosh, you think Nike. That is kind of the essence of trademark law. The crux of trademark law is brand confusion. So if you have a trademark, the main infringement case you would make is that someone else is either using your mark in a way that's going to cause confusion, consumer confusion, and that's typically the lawsuit that you would bring. Trademarks, you can file for trademarks, but trademark protection attaches when you're using a mark in commerce. So if you create some sort of logo or design, well, I won't use design. If you create a logo, you don't have to file a trademark application with the PTO for trademark protection to attach. That being said, if you don't file for one, your trademark rights are regional. So if I'm a business operating in California, I've got I've created this cool logo. I don't do anything about filing with the USPTO for protection over that trademark. I have the regional right to enforce that trademark in California and potentially kind of, adjacent regions, but I don't have a federal right. So if someone in Washington, DC is using that trademark in some sort of manner that would otherwise be infringing, I don't necessarily have the right to enforce that. So registration is beneficial because it creates a presumption of ownership and it has federal applicability. The presumption of ownership point is key in, for example, a lawsuit. So if you were bringing a suit against someone for trademark misuse or infringement, if you have a filed trademark, then you don't have to prove in court that you own that mark. Rather, the infringer has to prove that they weren't infringing it. So it creates that benefit as well. In licensing, really all you want to do with your trademark terms, if you're granting a right to use your trademark, and typically with our clients in the software space or for something like that, you often will have in your license agreement the right to use your customer's trademark in marketing materials. So you're working with a customer, you're working with a public company that's a customer. It would be great for your business to use that logo on your website to say, hey, Nike is a customer. Look how legit I am. Typically, the way you obtain that right is in your agreement with Nike, and you say, hey, Nike, I have the right to use your trademark on my website. And by having that in the agreement, Nike, in broad strokes, cannot really sue you for that, for placing their logo on your website. I say in broad strokes because there are some permutations to that, but we don't need to get into that at the moment. Anything else on trademark? Trade secret. So trade secret is sort of is one that doesn't neatly fall into any other buckets, but it's basically information that has economic value if you keep it secret, and that you've taken reasonable efforts to keep secret. So using an example, I'm not drinking Coke right now, but if I was, that's the most famous example of a trade secret, is the Coca-Cola formula. It's not protected by copyright. It's not fixed on a tangible medium of expression. Although I'm sure there are documents that have some sort of, formulation of what it is, but that's not the protection that they use. It's not protected by patent. So what do we have? Well, we have trade secret. They keep it secret, and that secrecy, they derive economic value from that secrecy. If Pepsi were to find the Coke formula, although Pepsi has their own formula, but if some competitor were to find out that formula, that would obviously be disastrous in the market to Coke. So the way that you protect trade secrets is typically through confidentiality provisions in your licensing agreement. So or under NDAs, and we'll talk about NDAs, but if you're going to be disclosing something that's, competitively sensitive to a potential client or a client that you're already working with, the way to protect that is through confidentiality terms, saying, hey, you're not going to disclose this information other than is necessary to, use our product, if at all. You're not going to use that information other than is necessary to use our product. And you're not going to disclose that to anyone, outside of your organization. And if you disclose it to employees, they need to have NDAs with you that protect that information. As long as you are taking that step to execute NDAs and protect the information, then that trade secret is economically beneficial to you, then you have trade secret protection without having to do any filings or anything like that. So that's trade secret. Daphne, you're unmuted, so I think you want to say something.
Oh, yes. So we've just run through all of these different rights that you have, and you use this to protect your IP, your products, and your services. But you also use these rights to monetize your products and services. So it's really important to think about all of these different buckets of rights. Because we're in this global economy, I want to touch on a right that really isn't as present in the US, but it certainly is in Europe and Canada, and that's a moral right. So that's kind of the right of attribution. And a quick story, in Toronto, there's this sculpture by a big mall of all of these little birds. Looks great. The artist licensed the right to a shopping center in Toronto. And then over the holidays, the shopping center decided to put nice little red bows on the necks of all of these birds. And the artist said, I did not give you the right to do that. You are violating my moral rights. And the artist sued the mall, and they had to remove the nice little bows around the necks of the birds. He also got monetary damages too, because the key argument there was, this is my work of art. I have not given you these moral rights, so you can't fiddle with things. And again, that's sort of the notion of attribution and one's right in what they've created. So you see these moral rights again in Canada and Europe, and you see it more in the world of artists and things like that, like movies, books, sculptures, and so forth.
Awesome. Yeah, and I think just to circle back on the point that Daphne just raised, the idea, hopefully, that you'll get with our presentation, and just the idea that we want to hammer home is, you want to monetize these these things, right? I mean, if you have you're Coca-Cola and you have a formula that everyone loves, it does you no good to just sit on that and say, hey, I have IP rights over this. That's great. I can sue whoever I want. What you want to do is you want to do business and use that right, and allow other people or allow other companies to exercise certain rights that you have in it, subject to limitations. That way you get money from it. So if you have, if you've developed some sort of method for something, you want to use that in commerce, and that's why we have licensing. I think I see a hand. Does that mean a question?
Yes. Yeah,
cool.
This is Mike. I have a question regarding what Daphne just mentioned about moral rights. Does that extend to in the realm of software, in like open source software, that even though I open source my software, but if you're used in a way that that is not intended, that I may object to that and then file some kind of legal action.
Daphne, you're on mute.
Sorry about that. I couldn't click that quickly enough. Okay, so Pete was talking about all the different buckets. So if you give someone the right to copy something, but they don't have the right to modify it, you can sue them. So that's separate from the moral rights. That would be what I just talked about now, is in the bucket of the copyrights. For moral rights, which aren't so much present in the US, except you touched on open source. You probably know in many open source licenses, they say, you've got to give the creator of the code attribution. You've got to put that in your header files that, you're using code from another person subject to a license and they want attribution. You don't see that too much in commercial licenses. In fact, I haven't seen it in a commercial license, but you certainly see it in open source licenses. So if you put in your agreement that the other party needs to mention that some of this code that they're using comes from you, and they don't do that, that would be a breach of the agreement. And also, it would be a breach of the agreement.
Just a quick follow-up is that because the open source license, the author can adapt any of the the common license that already exists, but he or she can also customize it.
Yes.
So let's say if I customize my license agreement for my code, say this cannot be used for, let's say, for military purpose, for example. Okay, just so if someone use that code to develop a weapon, is this some ground that I can withdraw that rights for them to use it?
Oh, definitely. So that would be, you're putting into an agreement, you can do X, Y, Z with this code. They go do W or something else, like your military example, you for sure can come after them.
Okay.
And so you would, in that case, they're going beyond the scope of the license. So you could sue them for breach of the contract.
Okay, thank you.
You can kind of think of it as not necessarily a Venn diagram, but sort of something that starts like large and goes small, right? So you have your statutory rights, and then you can limit, the statutory rights that you're granted, the right to copy, the right to publicly perform, the right to prepare derivative works, etc. You have those rights. In an agreement, you can whittle that down by saying, okay, you have the right to copy, but you don't have the right to prepare derivative works. And your agreement is what really is going to, as long as you're the rights holder, your agreement is going to govern the relationship between you and the counterparty and what they can and cannot do. So you can grant all the rights that you have under a copyright, or one of them, or two of them.
Okay,
all right. So we're going to jump. We've talked about sort of, background principles of IP law, the main ones to hit. we're going to jump into more of a kind of business practical framework here and go into licensing. One thing that you always want to think about, and especially applicable to our folks at CMU, is you want to consider who actually owns those IP rights, who actually owns that technology. If you're working, with an institution, an accelerator, some sponsor, they often actually own those rights. One common way that drugs are developed are, for example, like, I don't know, Advil or some, prescription well, that's a bad example, but if you're developing a medicine, let's say you're developing a medicine, that's generally going to be protected by patent. But that often is developed by professors, full tenure track professors at universities, because they're big research institutions and they have, the research institution brings to bear all sorts of knowledge and facilities and resources. And in exchange for making those available to the professor, the research institution typically owns any IP that's created by that professor. So let's say that professor comes up with this awesome new invention to cure cancer. Well, that's great, but if they've been doing it under the auspices of University of California at Berkeley, Berkeley's going to own that invention. So what does the inventor do? Well, he goes to Berkeley and he says, look, I've got this invention. I know you own it. I want to use it and I want to go commercialize it. So the university says, okay, how do we do that, right? Well, they enter into a licensing agreement where the inventor now has the right to go, work with Pfizer or someone to commercialize that invention and go sell it. The university is obviously going to take a cut of whatever money that they get down the road. And there are often going to be all sorts of other requirements in the license. And the university will often retain like an internal research use. But broadly speaking, if you're working with a university, a research institution, an accelerator, some kind of sponsor, they often actually own the IP that you develop under their auspices. And by auspices, I mean, at their facilities or in connection with the work you're doing with them. So this is just something to always have in the back of your mind if you go and work with what I'll call a sponsor. It's not necessarily fatal to you. And obviously there are really good reasons for working with a sponsor, like some of the ones I mentioned, resources being the main one, institutional expertise. But, when you're developing IP under those auspices, that is often going to be owned by the institution.
Yeah, and that's if you're, it doesn't have to be that you're a full professor or anything like that. If you're getting any money from a university, like you're a TA or whatever, and you're creating something using the university resources, like a lab or whatever, or doing it on kind of university time, or something that you actually already do for the university. Let's say you're researching things in some area and you create something, then that IP will vest in the university. So something to always remember. I think we have a quick question here.
Yeah.
Pete, I saw it for a second and it disappeared. Do you
No.
have it?
Yeah. We've got a question. Go ahead and unmute yourself. Fire away.
Oh, hi. I actually left my question on the chat because my surrounding is a bit noisy. So if you guys can hear me, I can speak it out.
Let's see. Yeah, I can hear you perfectly.
All right, so I'm actually doing a team project at school right now at CMU, and the IP from the project belongs to the members. And I was wondering, like, what would happen if I do the business later on with technology from the project later on without the other members participating? How will be the right distributed among the members, or like who can claim the right when doing business, or do I have to get consent from the other members to do the business if I were to employ the technology from the project?
Pete, can I make a suggestion that we take this offline, perhaps? so you can continue with the presentation. And if the person who asked the question wants to reach out, we can schedule some time and do a little office hour with them and give a little bit more of an appropriate answer. Does that sound okay, Pete?
Yeah, that's fine. I'll say one quick thing on that. You have to look at the documentation for who actually owns the IP, and if it's joint ownership, that gets pretty complex. So as Matt said, you'd want like a full kind of discussion on what IP it is, what the joint ownership terms are, and that things like that. So yeah, let's talk about that offline, because that can get pretty hairy.
Complex. Okay, thank you very much.
Yep. And we have a slide briefly covering joint IP, so we'll hopefully maybe that'll help address the question. Okay. All right. I'm not going to talk too much about NDAs, but just the point here is that if you're in discussions, or someone has reached out to you via email, or you reach out to someone via email, phone, whatever, and you're contemplating a business relationship with someone, get an NDA in place. And as I mentioned earlier, one of the primary protections for trade secret information is an NDA. It's always critical to have an NDA before you're talking to any business partners, even if you think the information that you disclose is not going to be necessarily that sensitive. Just always a good idea to have that. If you don't really have any protection for them going out and using the information or disclosing it. I'm also going to say one thing about sort of the difference in legal reality and practical reality. So if you often hear stories about a bright young founder who goes to work with a giant company, and I'll leave them unnamed, but you can think of some of them. And they go in and they say, hey, I've got this great idea. We've signed an NDA. I'm going to tell you everything about my business and look how awesome my invention is. That big company is under NDA with this founder, but goes, okay, thank you very much. We'll be in touch. And 2 months pass and the founder's browsing around online and sees that, hey, this big company has just basically done what I just told them. They've taken my my secret sauce, and they're about to release a product based on that. I had an NDA with them. What's your recourse? Well, you can sue them, but you're maybe a bootstrapped founder who's working out of their garage. How are you going to sue giant company X? With what money? What damages are you going to get? Right? It's a Herculean task. This happens all the time with startup founders who go to pitch their idea to some giant company. The giant company just essentially steals it. So the point is that the legal reality here is that, yes, I have a cause of action under my NDA because you breached it and I'm going to sue you. The practical reality is I don't have the money to sue you or the resources. You have a giant team of in-house lawyers and a bunch of outside counsel, like folks like me and Daphne, who are ready to, bring all sorts of counterclaims on you, make it super difficult for you to sue, et cetera, et cetera. So in practicality, you're kind of stuck and left without a good option, and your baby has just been stolen, right? And you can't really do anything about it. The reason I make this point is with an NDA, it's great to have it and you need it, and it's kind of a prerequisite, but don't go disclosing trade secret information just because you have an NDA. You always want to be careful about who you're talking to, what you're telling them, because the risk of, what I'll call theft of trade secret information is real, and it's something to keep very close to the vest.
Yeah, and I'll add in too, there are companies, and we've seen these companies prepare these NDAs that look great. It's a mutual NDA, you think it's fine, but then in the weeds of the document, they've stated that anything you present to them, they own. Like absolutely bizarre terms in certain NDAs. So even though it's an NDA that everyone signs, you need to read it. You need to look at every single bit of it. And if you don't understand something, the prudent thing is to call up an attorney and make sure that they go through that NDA very carefully.
Yep. So this is, kind of a prerequisite to your full licensing agreement. What is an IP license? We talked about that. It's basically the right to granting another party the right to exercise the rights that you have exclusively under law. So making a device covered by a patent, copying a work covered by a copyright, displaying a trademark. Why do you license? Well, as we talked about earlier, you want to monetize your IP. Why else? Well, you exercise control over your IP, right? You state in the license agreement who can use it, what can they do with it, when do I have the right to terminate their use? So you have there's typically an implied right to terminate the right to use if they breach the agreement. Breach is a fancy legal word for violate the terms of the agreement. But you want to set out very reasonably detailed termination rights. And that also corresponds with a term. So you might say, I'm granting you this right for 2 years. After 2 years, right expires. It's also a deviation from background legal principles. This is getting a little bit into the weeds, but there's a background set of laws that govern commercial relationships with goods or services. Generally, software is considered a good. This is called the UCC, the Uniform Commercial Code. Generally, a software is called a good. So if is deemed a good under the UCC. If you're providing software, what the UCC does is they have all these background principles about the seller's warranties of, I call them the seller, but we'll call it the licensor's warranties with respect to that software, including that it's fit for the purpose, fit for the buyer's purpose, that it's merchantable. So these are things that you typically want to deviate from in your contract, right? You generally want to say, especially if you're more early stage or you've got a beta product, you want to say, hey, notwithstanding anything in the law, in this contract, I'm not warranting about the performance of this product. So it's as is, and if it doesn't work, I'm sorry, but you can't come after me and sue me for some breach of warranty. And then another way, another good trick in licensing agreements is that you can allocate liability. So I won't go too detailed on the point of indemnity, but essentially, if I provide something to Daphne and Daphne gets sued for, let's say I've got a method and Daphne's using it to create, manufacture a phone or something. And a third party comes in and sues Daphne, who's selling these phones. Daphne's going to turn to me and say, hey, that was based on your IP. So what are you going to do for me? And typically you can allocate that liability back to the licensor because, hey, it's their IP, they're actually responsible. So, it's a way to allocate liability in a license. Another key provision with respect to liability in a license is, believe it or not, you generally can in your contract limit your liability to say, hey, notwithstanding anything in background law, my liability under this contract is going to be limited to X. You can put an arbitrary amount like $100, but what's more enforceable generally is to have that limitation of liability tie to the contract somehow. So if I'm licensing my software to you for $50 a month, it's more enforceable to say, instead of my liability is limited to $100, my liability is limited to the amounts that you've paid me for this software. And you can do that, and that is enforceable. We've got a chat. So any recommendations for those of us who consult with, mentor, or advise on behalf of multiple startups so their IP is protected, and at the same time, we aren't restricted from collaborating with other startups? Can who raised the question unmute and maybe elaborate on the question a little bit? Okay. So basically, I mean,
Yeah, I was, this is Martina.
Hi.
I was connecting my headphones. Yes, so I've been collaborating with multiple startups. Some of them are pretty early stage, but it's clear that some of them will have intellectual property. And so far, I did not really need to sign any like non-disclosure agreements, but I know that at certain point it will come. And I think there is like a narrow bound in the startups having their intellectual property and inventions protected. But the people who collaborate with also, if they are collaborating with multiple startups, they don't want to be restricted. So let's say somebody is doing, let's say, EHR with respect to AI. They don't want to be excluded from consulting for EHR, electronic health records, and AI for all other companies. Does this help?
Yeah. So if you're talking about from the consultant's perspective, you know, unless you're typically, so the way IP protection works is that unless there's an agreement to the contrary, or unless there's like an employment relationship or a university relationship, the person who creates the IP or creates the technology is the one who's going to own the IP rights in it. So if you're working with a startup, I guess, are you providing like, protectable ideas or things that you want to protect, or are you?
No, no, I'm providing consulting services and advisory, but at the same time, the startups may be discussing something that may be proprietary.
Gotcha. Yeah, and you would want to potentially reveal that information in your other work?
No, I don't want to reveal it to others, but if somebody requires that you sign non-disclosure,
right,
then you may not be able to work with other similar companies.
Well, not exactly. I mean, a non-disclosure agreement is going to protect information that they disclose to you that is, competitively sensitive or secretive, but you can, that's not a non-compete. A non-compete is kind of a different thing. A non-compete is a contractual term that says you can't provide similar services to other parties. But as long as you're not disclosing information that's covered under the NDA, which I don't imagine you would need to, then an NDA wouldn't prohibit you from doing that work. I mean, consultants do this. This is totally standard, right? A consultant is going to work, if you're an industry expert, you're going to be working with multiple companies in the industry, and there's no expectation that you can't do your work with similar companies. You just, if you signed an NDA, wouldn't be able to disclose, competitively sensitive information or information that's defined as confidential information under the NDA.
If I could jump in for a minute.
Yeah.
So, Martina, one of the things that I regularly tell people who are doing that consulting work for multiple companies, the idea is if you do anything at any particular company, you should have no expectation at all of being able to take something that is confidential that you learn at that company and ever tell it to anybody else. That's just an unfair thing for you to expect. But the reason I jumped in is from the flip side. If you think about these startups, one of the things that is imperative to them is to keep their information, their confidential information, private. When they go out and seek funding, it's one of the things that investors look at is to make sure that the integrity of the company's IP has been protected. And the only way that that is done is companies, startups, make each and every person, employees, the receptionist, anybody who comes near anything that is confidential, the company makes them sign something that says, you will not learn something about my company and share it with others. So in our world, it is incredibly logical that you as an advisor or consultant will respect the integrity of each and every company's intellectual property. And if you do that, you're free to consult, like we consult with, obviously in a different realm, but we consult with hundreds of companies, and we never disclose anything we learn from any one of them to any other. Is that helpful?
Definitely, thank you. And I'm all for the integrity and protecting the companies.
Of course you are.
Excellent. One quick thing I'll add is that I understand the consulting that you were just mentioning. There are cases where people are doing consulting in the sense of they may develop some code, or they may create something else that is protectable. Remember, we talked about all those different buckets. And in that case, if you've got a person who's an advisor within that kind of sphere, you want to make sure that you have them execute an agreement. This is if it's your company, to ensure that anything that's created, you know, as they work for you, is owned by the company. And that there isn't any question about that, because again, when investors look at your company, they're going to want to make sure that you actually own or have sufficient rights to kind of the crown jewels of the company. So whatever kind of IP has been created for the company to use.
All right.
Okay, thank you.
So is this, Matt, is this an hour long? Okay, so we're at 4 minutes. So I'm trying to, let's see.
We're either going to do
Yeah.
we're either going to do a part 2,
Yeah.
or people can reach out with their questions and we can hold office hours for them.
Yeah.
But do you want to take 2 minutes and just sort of summarize how the license fits together?
Yeah, we'll do
Okay.
that.
You
So
did that in my class the other night brilliantly. So thank you.
okay. So, you know, the way a license works is you have the license grant, you have the parties first. So who's granting what to who? If you're working with an entity, you typically want to just grant it to the entity, not necessarily all their subsidiaries. So if you're working with a company like Nike or something, they probably have a lot of subsidiaries. You just want to grant it to one entity. And the grant also, by the way, needs to be a present grant. So you have to say, licensor grants licensee, blah, 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 not licensor will grant or licensor may grant. It needs to be a present grant through the document. Always specify what, you know, always specify the rights that you're granting them. So we encourage our clients to use the rights that are in the statute. So if it's copyright, use is starred, because you typically don't want to use that right, or use that language. But if it's copyright, you know, reproduce, publish, create derivative works, etc. If it's patent, make, use, have made. Then you know, there are all sorts of ways you can go with a license. It can be an exclusive license. We don't typically recommend exclusive licensing unless there's some really good reason for that, because if you exclusively license it to Matt, then you might not be able to license it to Daphne, depending on the parameters of that license. So typically, you know, you grant a non-exclusive license. You might grant territorial restrictions. So I grant you the right to use the word use, to use my IP in a certain area, but not in this other area. So if it's a license to sell something, you can sell it in India, you can't sell it in the United States, something like that. Payment obligations, obviously. So how are you going to get paid? Is it going to be a monthly fee? Is it going to get a fee? Is it going to be a royalty where it's a fee based on, you know, units that are sold? So these are things you want to think about. I'm not going to go through sample grants. You always want to clarify in a in a license that, you know, I'm granting you this license, but I'm not granting you any other rights. And all my other rights are reserved to me. This is important, especially in the and this became a big issue in the software realm with end user licenses, because under background principles of copyright law, for example, if you convey a copy to someone, they have certain rights under the first sale doctrine to distribute that copy. So in order to avoid that consequence, you say this is licensed, not sold. Yeah, just something to think about. And then some restrictions, right? You want to make sure that there are restrictions on their ability. So if it's software, you don't want to allow them to reverse engineer it. You don't want to allow them to combine it with open source, you know, things like that. You want to state, and we have sort of, there's what, I don't like to use this term, but there's boilerplate restrictions that go into most licenses that we have, restricting the licensee from doing various things with the work. Term, you know, like I said, do you want it to be 2 years? Do you want it to be 1 month? How does the agreement terminate? You know, you typically want to set out those rights. Fees, we sort of talked about. Allocation of liability, we talked about. Probably don't need to go through miscellaneous. To close in the last, well, we're already 1 minute over, but to close with a couple of traps for the unwary. If you're running a company, PIAs and CIAs, proprietary information and invention assignments, or confidential information and invention assignment agreements, are the agreements that you want to have in place with everyone who's working for your company, including employees, including contractors, including advisors, where they assign, as Daphne said earlier, they assign any IP that gets created to you, because you want to own all that IP. That your company should own all the IP that's being created for it. And the way you do that is through these proprietary information and invention assignments. I'm probably not going to talk about work made for hire, but joint ownership, going back to the question earlier, you typically want to avoid joint ownership if you can, because if you have joint owners, there are certain issues presented by certain areas of background law that make joint ownership very difficult to navigate. So in copyright, you have a duty to account and share proceeds. In patent, one of the main issues is that in order to sue for infringement, you need all the joint owners to join that lawsuit. So if Daphne and I have created something that's patentable, and I go see that someone's infringing it out in the market, and Daphne, for whatever reason, doesn't want to join that lawsuit, I'm out of luck. So joint ownership, again, we can have a follow-up chat with the individual who raised the question, but that's a very hairy issue that you typically want to avoid. And there was one question about the office hours and a quick question.
I guess we'll coordinate with folks to figure out, Allison and others, to figure out when we can provide some office hours. And then we'll also, with that, give you our numbers so you can give us a ring. We love discussing this stuff. So we're definitely available to do so.